Some people call it a rude manner. Turn it off.
You're watching the Law and Crime Network. We're taking some time away from our review of trials to talk about what we think is a list of the top 12 lawsuits litigated in the year 2017 in some fashion. Now, disclaimer, some of these are valid legal claims, but the facts are bizarre enough that we think require inclusion in our list. Ken Belkin, Heather Hansen here along with me to talk about these. Let's dive right in. Number 12 on our list, a bag of veggie straws doesn't contain actual veggies. Here's the claim. You see the picture on your screen right now. Because there are photos of a real potato and a real tomato and real spinach on the front of the bag, apparently that's what should be inside the bag. Thoughts?
Listen, I think it's a valid claim. I mean, it says veggie straws, right? Veggie. It doesn't say potato straws. And you've got pictures of the vegetables. I do think we're going to see more and more cases like this, Aaron, because people are really into eating organic. They want to make sure that they're actually eating what they think that they're eating. And when you advertise that something contains vegetables, maybe it should.
Well, it does contain vegetables. It has potato in it. You know, they're all ground up and processed, but in the other flavors are in there.
Yeah,
you know what people like doing more than eating organically? Filing frivolous lawsuits. This is a frivolous lawsuit. Oh, it doesn't have real potatoes, spinach, and tomato in it. It does have a powdered form of them. I got news for you. Grape soda doesn't have real grapes in it.
Oh, you just spoiled my whole weekend.
You know, come on. I'm sorry to break that to you, Aaron, and you are wearing a wonderful grape soda colored tie.
I didn't think of it that way up until now, but you've now ruined my wardrobe too. Thanks, Ken.
See, I love grape soda, but grape soda I know isn't good for me. I think some people are expecting something that's called veggie straws, perhaps to have something that's good for them in it.
Yeah, and exactly. There was one commentator who said that this is a growing number of so-called courtroom food fights.
Yeah.
And look, I agree with you, Heather, that we're probably going to see more of these as people demand better ingredients from processors. But look, these things, in the manufacturer's defense, apparently contain 30% less fat than regular, ordinary, run-of-the-mill potato chips. So are we bashing the wrong food producer?
And by the
here?
way, what's to stop these people from looking at the ingredients list?
Exactly.
You're required to put an ingredients list on products. Take a look at the ingredients list. Newsflash, just because it's got a picture of a carrot on it, if you're buying it shrink wrapped in a bodega or whatever, and it says carrot powder, you know, you get what you pay for.
Yeah, I think that that's probably true, but I have a feeling these people are not really suing for money so much as to change the rules to make sure that the percentage of vegetables is whatever the law says it's supposed to be. And a lot of these cases I know from reading your summaries, Aaron, were filed in California, and I think this one was one of them.
This one was a New York one, but we're going to get to a California one next because there's another similar case. Okay, here's the next one. This is number 11 on our list of the top crazy lawsuits. We're counting down for you. Here's number 11. Jelly Belly gets sued by an athlete over evaporated cane juice in so-called sport beans. Apparently, jelly beans have too much sugar. Who would have known?
Oh.
Yeah, this one's, see, now I'm with you on this one.
Jelly
Ken.
Belly, don't do that to Jelly Belly.
But this is a stretch. I mean, they're jelly beans. And if you don't expect them to have sugar in them, I think you probably have a bit of a problem. You need to be reading the ingredients, and you need to understand that, you know, just because something says for athletes doesn't mean that it's good for you. You have to do a little bit more research than that.
Yeah, exactly.
Look, I think it's no secret. The sugar industry is going through a little bit of a PR nightmare. Every health ailment, every medical condition is now squarely blamed on sugar these days. And they've resorted to tactics such as, oh, instead of calling it sugar, we'll call it evaporated cane juice.
And that's what's underlying this.
We are 2 steps away from putting it on ingredients lists as magic zippy powder.
Okay, well, you know, you could say that, but look, I mean, underlying this is a whole regulatory legal issue about what we're going to call the ingredients. And the Food and Drug Administration has basically said, look, evaporated cane juice is sugar. You shouldn't be twisting the language like this, but they said shouldn't, didn't say can't,
right.
So people are still going to do it.
Well,
and that's an interesting legal question.
It's buyer beware, though. I mean, to Ken's point, read the ingredients, be aware of what types of sugar there are and what you're actually eating and what you're putting into your body. And to file a lawsuit over this type of thing, I mean, I do understand that it's meant to change the regulations and make them more specific, but it's also a huge waste of time and money and resources, and at some point gets a little bit silly.
People can change, they can start calling sugar whatever they want. As I said before, magic sippy powder. It's a joke, but it's true. They changed the name of sugar several times over, but at the end of the day, there is that nutritional facts box on packaging.
And that was part of the defendant Jelly
what
Belly's
sugar.
claim. They said, look, read the ingredients. So we'll move on our list. Number 10, a Santa Claus who photographed himself wearing a Santa outfit and holding a rifle claims he got fired from his job for the photo. There you see it on your screen. He was working for the Department of Health and Human Services in the state of Michigan. According to a local newspaper there, he claims that the reason he lost his job was because his boss caught wind of the photo, and that's when all of the pretext came down. They started hammering the guy, picking apart his performance, and they cut him loose right before the end of a probationary period. Part of me wonders if this one's got some merit. I mean, it's a strange factual circumstance, but look, he's a military veteran. He took the photo with some of his war medals. You can see him in the background. Look, this one at least I think needs to get to a jury.
I agree with you, Aaron, and especially because apparently one of his supervisors was telling other people to look out for him because he was a vet and because he was shooting himself with guns as if he was some sort of a danger. There definitely seems to be an issue here that at the very least should be explored.
Santa Claus knows when you've been bad or good, so be good for goodness sake.
Yeah, especially this Santa. He's packing heat.
Exactly.
Oh, look, gun-toting Santa got fired, can't be a child protective services worker. I don't know that that's such a bad thing, that the guy who doesn't have the wherewithal to understand that maybe taking pictures with a rifle while in a Santa...
I don't know, Ken. Look, he's got a right to bear arms. It's not like he's bringing it to the mall.
Hold on. No one's saying he doesn't have a right to bear arms. What I'm saying is maybe he doesn't have a right to work with children if he's going to be taking photos like that. Now look, I don't know that firing him was permissible. PTSD might qualify under the Americans with Disabilities Act as something actionable, and he shouldn't be discriminated on the basis for having it. But I'm real curious how he got past the hiring process.
Yeah, but I'm not even sure he had PTSD. I think the fact that he wants to take a picture on his own time, dressed as Santa with a gun, it's going to be difficult because there's a lot of constitutional issues that come up with this, whether it be PTSD, whether it be the Second Amendment, whether it be some other form of discrimination. I do think that it's something that at the very least deserves some more investigation.
Look, he has the right to express himself. He has the right to bear arms. He doesn't have the right to work with children if he's going to be taking pictures like that.
Interesting debate. I'm sure we could continue it without problem with this panel. Let's move on. Number 9 on our list. A man in New Jersey trips over a Christmas tree that was partially on a sidewalk. Now, this isn't an actual photo of the way it was, but you've seen these around. We've got pictures to illustrate it. People throw the Christmas trees out on the sidewalk. They're going to be picked up by the city. So it's a situation similar to what you're looking at. He trips on the thing, falls, sues for a ton of money. Discuss.
Well, as a Brooklyn Jew, this might be the only thing I never get sued for. But I'll tell you, look, this is basic. There's sidewalk laws in almost every jurisdiction. The real property owner of a piece of property that abuts a piece of sidewalk is responsible for keeping that piece of sidewalk free and clear.
Yeah, it's not a sort of frivolous claim if the person was actually hurt, and the sidewalk should be clear and able to be passed.
Yeah, so and in no way are we making light of the injury. It's the factual scenario underlying it. Is just kind of like, okay, how long was the questions to ask if you're a slip and fall lawyer? How long was the tree there? How much was it protruding onto the sidewalk? And depending on the negligence laws in that state, to what percentage or degree was the plaintiff
and the
defendant liable for the injury?
Right. Did you try to avoid it? Did you try to step over it? Were you just barreling down the sidewalk, not paying attention? Were you aware that it was there? There's all kinds of questions.
And this just firmly establishes what I've been saying for years. Hanukkah is way more safe than Christmas.
Lighting fires, 8 candles burning all over the place.
All right, fire thing's a little problematic.
Yeah, that might be next year's list of lawsuits.
We need to look into it. I bet they're there. I bet they're there.
Number 8 on our list, we're continuing to move through. A woman slams into a ladder while texting. She had passed the thing several times. Again, this is for illustration purposes only. A similar ladder to the ones you see stacked up there. The lawsuit says it was bright orange. She walks past it, comes out of a store, walks past it again. Then she walks past it, I think on the third time, slams into the thing while she's texting. Okay, the jury gives her $161,000. This is a case out of the state of Georgia.
I've got to imagine she was pretty injured to get $161,000. And the other thing that I think happened there is, we talk about this all the time on the Law and Crime Network. The jurors could probably relate to this lady. I mean, how many of us have done the same thing? The unfortunate truth is that we do. And I bet that they had some surveillance on that lady and showed exactly how this happened.
They did have surveillance. I have not seen it, but they did have it.
And look, these people, they could have put up some sort of sign, something around the brightly colored ladder that she clearly didn't notice because she was engorged in texting. But, they could have done something to help alert people that were walking by.
One would think possibly. Even the plaintiff's own lawyer said he was shocked at the level of the award. So we'll leave that for consideration. But we will move on. Number 7 on our list. A lawyer in Florida sues another lawyer over the strength of a painful handshake. This actually did happen. Lawyer shakes the hand of another lawyer at a party. The plaintiff claims it left him in pain for years due to the tightness of the grasp. Now, apparently, if I see either of you in passing, I'm just going to do nothing other than a lukewarm nod and a slight lukewarm smile.
I gotta ask you, Heather, how's my handshake?
I'm nervous. Oh, you're fine.
Yours
you're
is
okay.
more strong than mine, actually.
You're okay.
All right,
I think you're all right.
Should
I
it be
think
stronger,
fist bump
do you think?
is okay, or even elbow bump to avoid
Yeah, I mean, the bottom line in this one, the plaintiff, any guesses? Do you think the plaintiff recovered?
Well, we saw your memo, Aaron. So
that's right. I gave it away. I forgot.
I actually don't remember, though. I don't remember.
I had to look this one up. Plaintiff did not get a dime, and the defendant is actually seeking to recoup some attorney's fees under a law in Florida.
But the thing is, they had shook hands before, right?
Yes.
So I think that there's something more to this.
Assumption of the risk.
Yeah,
you knew what you're getting into with that handshake.
Exactly. Not a bad jury decision. Okay, we'll move on here. Number 6 on our list. A woman sues a restaurant also in Florida after falling off of a statue of a donkey. She said that the statue was smooth and slick, and apparently she thinks it needed steps, a ladder, some kind of non-slip markings, because apparently this thing is a bit of an attraction at this restaurant. I tried to find a full photo of the thing, was not able to find one without 15 million people climbing all over it, and it makes the size of it a bit hard to guess based on the photos I saw. So I don't know about this one.
I noticed you looked at my head when you said smooth and slick.
I did not.
I couldn't help but notice your eyes glanced
That
upward.
did not happen whatsoever.
Upward glance. But look, if the restaurant knows that people are climbing on this thing, they should put signs up. They should put something around it to let people know, do not climb on this donkey.
Climb at your own risk.
Yeah.
I mean, something, but it seems as though people in that community really want the donkey to stay there. And it does, it's a shame that people end up filing lawsuits, and oftentimes these types of things happen and they no longer have these types of things out there for people to climb on and hurt themselves on.
It's worth the legal point, I think, that if you're running a business, you have a very high level of what we call premises liability.
Yeah.
You have to make everything safe for everybody.
Right.
And, that plays in here. If you know people are climbing all over this thing, even if it's for fun, look, there's a heightened duty of care there.
Yeah, but if no one else has injured themselves on the donkey, I think that that's going to be supportive of the defense that maybe it was just this woman and the way that she climbed the donkey or her lack of coordination.
Well,
skills.
this donkey is clearly not meant to be climbed, and it's foreseeable. They knew that people were doing this all the time. They should have taken some steps to prevent it.
Let's move on our list here now. Number 5, a satanic band. Lead singer gets sued for putting darkness into the lives of bandmates. The
Aaron,
band
I'm going to sue you for putting darkness into my life.
Okay, apparently it has to do with unpaid fees. Apparently he forced band members to clean his musty costumes, clashed with them while on tour, financially shortchanged him. That's the language of the suit. The band is named Ghost, and the lead singer is known publicly as Papa Emeritus. The claim involved accusations of greed, darkness. They were looking for about $22,000. What's interesting for fans of the band is the lawsuit revealed everybody's real names.
Right. I mean, that's one of the good things about checking a docket, right? You get some information you wouldn't otherwise have. But it sounds like just a contract case that they really put into writing in a very interesting way, talking about bringing down the darkness.
It's like breach of contract, very artfully pled.
Right, right.
Yeah, number 4 on our list here, a teenager sues his mother for taking away his phone. Now, this is out of Spain, and of course, we are not licensed to practice in Spain. Could we just imagine the number of lawsuits that could be filed if American courts gave teenagers a claim of action against their parents? The teenager's claim here is, I wanted to play on my phone, my mother wanted me to study.
Yeah, it would never fly here, because that's all that our lawyers would be doing, and our courts would be filled with parents and children fighting over phones, which happens enough at home.
Yeah, I would be representing the parents in the counterclaim for being reimbursed for that phone expense.
Oh, yeah,
15-year-old wants to sue for their cell phone, they might want to pay for it too.
Look, of course, the court took a look at this and said, forget it. They dismissed the teenager's claim, said the parent was, quote, well within her rights to discipline the teenager. The court said, quote, she would not be a responsible mother if she allowed her son to be distracted by the mobile phone and fail to study. So
it's good rule.
Common sense. We oftentimes see in the chat rooms here at Law&Crime people asking for common sense decisions. This is one of them.
Absolutely. And how did it even get started? You wonder whether the teenager filed that case on his own, or whether he had what lawyer would actually take
what
that
lawyer is
case?
taking that case?
Be the big winner.
Mom took your cell phone. You better get down to my office and sign
I don't
a
know.
retainer
I should
agreement.
take Ken's phone away. Let's see how long he can survive without it.
Aaron, be careful. Okay?
Let's slide this thing across
There's
the
a
table.
lot of privileged content.
That's
on that phone.
true. I don't want to represent your clients. You can have them all to yourself.
Thank you. Thank you.
Okay, let's move on with our analysis here. Number 3. This one's really interesting. We could dive deep on this one. A sports fan sues a rival team and a player for that rival team in Texas, claiming that a dirty play injured his favorite team's player and diminished the value of his floor tickets.
I thought this one was interesting.
It's
and
really
ingenious.
interesting.
You know,
Really
I don't know how much it will actually fly, because it's a slippery slope and may open up all kinds of cases, suing members of other teams contrary to your team and not liking a call and so forth, suing refs for making wrong calls. But I do think that he's got an interesting claim, because there are certainly damages, right? That they put out season tickets and aren't able to get the full value of those tickets, and someone did something wrong. I mean, according to even the ref, I think they said that whatever this
the
guy
coach
did,
threw a fit about it and said, look, you've got a player, so the home team here is the Spurs, San Antonio Spurs. That's the team that the plaintiffs loved, and they cast themselves as diehard, that they have modeled their own lives to basically try to emulate the success of the team. I mean, this lawsuit, if you read it, really lays the language on thick for the team. People, these fans are really, really hardcore.
Fans,
and they're suing the Golden State Warriors and a player on the Warriors who made this play. The coach for the Spurs said that it was just a dirty play, nobody does it, but the NBA didn't take action against it. But look, I mean, a question that I have is, does the opposing team have a duty to the ticket holders of the home team? Or what's the opposing team supposed to do? Play lousy basketball so that the home team audience...
the conduct was wrongful. Right. It wasn't like they were playing lousy basketball. They committed a wrong act. But the real question is, how is this guy going to allege some sort of economic loss unless he intended to sell those tickets on the secondary market and the resale value was impacted, which I don't know that he's legally allowed to do in that state.
Different states have different rules on it. I remember when I worked in Missouri at the time, ticket scalping was legal, and there were a lot of sports memorabilia stores that basically would buy up groups of tickets and resell them, and that may also be legal in Texas.
Unless that's the case, he is getting what he paid for with his tickets. His tickets will give him access and entry to those games that he purchased tickets for. Otherwise, he's really not suffering a loss. Now, if he had bought those tickets with the intention of reselling them because people want to see this star player that's not able to play, then that's a different story. But still, a bit of a stretch.
Yeah, let's move on to our number 2 crazy trial for the year 2017. A man sues Uber for millions of dollars, claiming that a bug in the app led to his divorce. This is a case out of France. Guy suing for $48 million, claiming he used his wife's phone to basically book a couple of rides to go who knows where. And that later, even though he logged out of the app, it was sending his wife's phone notifications about where he was going. She gets a look at it. She doesn't like it. She divorces him. He sues Uber.
That's what led to the divorce? Uber? Really, buddy? I don't think we're being totally honest with ourselves. Come on.
$48 million. I mean, was that how much the divorce cost him? I find that really hard.
I wish I was the attorney on that divorce. Oh, my God.
I was wondering about that. So another bizarre case, but, look, I mean, I don't know how France would even examine this thing legally, but again, what percentage of the harm is borne by which party here? Is the husband not the one that's at fault?
Right, and is it foreseeable that his wife is going to see that if he's using her phone to book these rides?
And what duty does Uber have to cover up his affairs? if Uber and Tinder and all these apps, if they have to cover up people's nefarious, activities, well, we're in for a lot of lawsuits. Okay?
Oh yeah. Okay. Number 1 here. This was a clear number 1 of all the cases I looked at. A man in Texas sues his date for $17.31, the cost of a 3D movie ticket, because he says she texted through the movie and didn't pay any attention to him and ruined the experience.
It's a big money case.
Big money case. Small claims case.
He's just really mad. He's really mad about the bad date, and he's really mad about texting. I think he's more mad about texting than he is about the bad date. He really takes issue with people texting during movies.
Yeah, people just can't let a bad date die gracefully. This woman goes on a date with him, goes to the movies. She's like, all right, not having a great time.
She
texting
claims
her sister.
She claims that a friend was having a fight with a boyfriend, and that she wanted to comfort her friend in the midst of this. And it's like, well, you've got your date sitting next to you. Apparently, he asked her to leave the theater and said, if this is really important, perhaps you should take it outside. She gets up, leaves, doesn't come back. Interestingly, she's the one who drove.
She left him there.
So she left him there. He doesn't sue for the cost of the cab ride home, but he sues for the cost of the ticket. It was a local reporter who tipped the woman off to the presence of the small claims case.
This is a stirring defense on her part. I think she's got a great defense. I wonder, maybe the fact that he filed suit might have been so he could get a second date.
Right.
Because I don't think there was going to be one in the absence of a lawsuit.
There's got to be something going on under the covers here, or perhaps not.
The third date is going to be the appeal.
He's hoping to go
the third date is the appeal.
Third date appeal. That's the rule, right?
Listen, it would be a cute meat story if they ended up together after all this.
I don't know. Look,
Are you going on a second date?
The small claims case said, quote, while damages sought are modest, the defendant's behavior is a threat to civilized society.
Ooh.
The texting in movie theaters really makes some people mad. Clearly, the small claims court, one of them. I bet Judge Judy wouldn't like it.
This would be a great Judge Judy case. A great Judge Judy case. Look, I think that the debate is about whose dating life this lawsuit is going to harm more, the woman or the man.
By the way,
both of them are in some trouble.
I've gone on a lot of first dates in the past year. I think I might have to start bringing suit. I'm going to recover some damages.
And
a lot
we
of those
will be
dates
here
didn't like
next
it.
year questioning whether or not Ken is still single after employing that tactic.
Question? The answer probably yes.
Well, yes. We don't have to question it. So anyway, that's our review of what we thought were the craziest cases filed or litigated in the year 2017. We hope you enjoyed it. Again, some of these seem to have some real legal merit, but the facts are just bizarre.
All of them.
All of them. I don't know.
I don't know about all of them. Some of these are definitely a misuse of our system, but some of them are interesting, and we'll keep an eye on them. I think we'll see more of some of these cases. Maybe not the bad dates.
All right. Thank you for watching our review of these cases. Let's switch over now to our live trial.